My dear students, today I propose to distinguish between three concepts. One is valid contract, void agreement, and voidable contract. Now, at the outset, you must understand that in a valid contract, there is genuine consent, competent parties, lawful consideration, and lawful object. But whereas in a void agreement, absolutely there is no consent. There are no competent parties and there is no lawful consideration, and object also is not lawful. But whereas in a voidable contract, consent is only apparent. Consent is there, but it is not genuine. Why do you say it is not genuine? Because consent has been obtained by force, by undue influence, under threat. That is why consent is only apparent but not genuine. So these are the first primary distinctions among these three concepts, namely valid contract, void agreement, and voidable contract. The second aspect is, in a valid contract, both the parties can sue. It is enforceable through a court of law. But void agreement, ab initio it is void. A contract with a minor, Mohori Bibi versus Dharmadas Kush, famous case. So it is ab initio. Ab initio means right up from the start. Right up from the beginning, it is said to be void. Void means it is not valid. It is invalid. But whereas in a voidable contract, it can be enforced at the option of one party. Which party can enforce and which party cannot enforce? The party who has given the consent under duress, the party who has been made to give his consent under threat or by misleading him, that party alone can enforce the contract or can reject enforcement of the contract. But not the party who has illegally and under force who has obtained the consent. That is why it is known as voidable or optional. So this is the basic differences. These are the basic differences among these three concepts, namely valid contract, void agreement, and voidable contract. Now, having told you briefly about these aspects, let me take up the first and foremost important ingredient, namely offer. What is offer? Offer is a proposal. Now, I have simplified the definition of offer. It is nothing but communication of an idea by one person to another in order to get the assent of the latter, either for doing a job or for not doing a job. This is how I have defined. Now, there are rules that govern the Contract Act as regards the offers that are made in order to convert them into promise and agreement. Now, what are the rules? At the outset, you must know that the entire contract, which is an enforceable agreement, consists of two important parts. Number one is recital part. Number two is operational part. The recital part actually describes the residence of the party, the name of the party, and the age and his present status and all that. So that is what is known as a recital clause, namely one who enters into the contract and the person with whom it is entered into. So the offer and acceptance, that is there. Operative clause is conditional clauses. What are the conditions to be fulfilled? What are the obligations to be fulfilled? What are the rights that can be enforced, against whom, so on and so forth. As and when we deal with the subject, you will be able to know part by part the enforcement aspect of it. Now let us now narrate the rules. The rules are very, very important with regard to understanding the enforcement of a contract. Now let us try to know the rules as regards offer. Rule number one, offer must give rise to legal consequences. Rule number two, offer must be capable of creating legal relation. Rule number three, an offer must be certain or capable of being made certain. Rule number 4, offer must be distinguished from a quotation or invitation to an offer, where we are going to deal with auction cases. Then the very next important condition is an offer, namely specific offer, must be distinguished from general offer. There is a famous case, even today it is cited, known as Carbolic Smoke Ball, Carlyle versus Carbolic Smoke Ball Company. In other words, they call it as Carbolic Smoke Ball Company. Carlyle versus Carbolic Smoke Ball Company is the correct caption of the case. Well, that is the difference between general offer and specific offer. Then you must differentiate between continuing offer and specific offer. The next important point is offer must be communicated. Very, very important. Communication of an offer is very important for conversion of the contract. Then the attention of the offeree must be brought to the knowledge of the offer. That is very, very important. The knowledge of the offeree, in other words, attention of the offeree must be drawn by the offerer, about which we are going to narrate case laws also. These are the conditions you must know about offer. These are the 8 rules. So that must be understood properly, and you must be thorough with it. And the case laws are also cited there. The next important part is acceptance. As you know, offer must be accepted. Unless offer is accepted, there cannot be a promise. Again, promise must be supported by consideration. And then it becomes agreement, which must be enforceable at law. Then only it becomes a contract. That you know already. Now, what are the rules that are applicable with regard to acceptance? First and foremost rule is acceptance must be communicated. Just like offer is communicated, acceptance must be communicated. Communication of acceptance is very, very important. I have already told you, unless there is communication, there cannot be consensus ad idem. That is identity of mind. So, acceptance must be communicated. The next important thing is, it is left open to the offerer to waive acceptance. Waive means forego. In implied contract, no acceptance is conveyed through words. The very conduct itself amounts to acceptance. You get into a bus. It is the ingredient of an implied contract. It is implied that you propose to travel to a particular destination. So, it is left open to the offerer to waive acceptance. So, the next rule is that acceptor must understand that it is left open to the offerer to waive acceptance. Here, silence cannot be prescribed as a medium of communication. Communication itself is through words or by conduct. But silence cannot be prescribed as a medium of communication. Invariably, we receive notices from the income tax and sales tax department. If we do not receive a reply for this pre-assessment notice within 15 days, you are deemed to have accepted the terms and conditions of this notice. Well, there, it is not silence that is prescribed as a medium. If you are silent, when you are silent means silence amounts to acceptance. Where there is a duty for you to speak and to reply, when you do not actually comply with the duty and send your reply, you are deemed to have accepted. Silence amounts to acceptance. But you must understand, silence cannot be prescribed as a medium of communication. There is a famous case, Feldhaus versus Binley. In that particular case, the uncle wrote a letter to his nephew proposing to purchase his horse. The uncle wrote in that letter that if I do not hear anything about the horse by way of reply, I will deem it as if you have sold the horse to me. Now here, he has prescribed silence. If that fellow has not, meanwhile by the time the letter was received, the nephew has sold the horse to somebody and he could not reply. So that means silence is being prescribed as a medium of communication, which is not correct. That is that. Then the next important rule with regard to acceptance is, acceptance concludes contract. Unless there is acceptance, there cannot be any conclusion of contract. Here, You must understand acceptance through post. When persons are physically present, facing each other, both the offerer and the acceptor, absolutely no difficulty. Offerer can change his offer, alter his offer. Acceptor can also change his acceptance, and alteration of acceptance is possible when both the parties are facing each other face to face. But if the offerer is residing in one place and acceptor is residing in a remote place, when they are exchanging their offer and acceptance through letter or through, say, communication by electronic devices, now the question arises as to when the offer is said to be concluded, when it is made or when it is received by the acceptor. When you make an offer, do you mean to say that the offer has become complete? No, it must reach the knowledge of the offeree, namely the acceptor. See, when an offer is made to one person, supposing it is received by a different person, the offer is not said to be communicated. Communication is not complete. Even if the acceptor happens to be an illiterate, unless he understands the terms and conditions of offer, he is not said to have understood the terms and conditions of offer. Therefore, offer must be communicated. Communication of an offer is said to be complete unless it reaches the knowledge of the acceptor, namely the offeree. Section 4. That is very, very important. Communication of acceptance. The next important thing with regard to acceptance is, when do you say an acceptance is said to be complete? The completion of communication of acceptance is said to be complete the moment it is posted, and irrespective of the fact whether it is received by the offerer or not. When once it has been posted through post office, or when once you have posted the letter in the post box, and when it is no longer possible for the acceptor to withdraw the letter, it is said to be complete. Therefore, an offer can be revoked at any time before it is accepted. When once it has been accepted, offer cannot be revoked. That is why an acceptance to an offer is said to be a lighted match to a train of gunpowder. An offer is compared to a gunpowder, and acceptance is compared to a lighted match. And when once the gunpowder is lighted by a matchstick, immediately contract explodes. Therefore, if you do not want the contract to blossom, what you should do or burst, you should withdraw the gunpowder. You should withdraw the offer before it is accepted. That is why an acceptance to an offer is just like a lighted match to a train of gunpowder. So, communication of acceptance has been viewed from two angles. One, as against the offeror. Communication of acceptance is said to be complete as against the offeror when the acceptor has posted the letter through post box. Irrespective of the fact whether the letter is received by the offeror or not, when once the acceptor has posted the letter, his responsibility is over. That is why invariably we find when any letter is posted or sent by registered post by any office, they say that our responsibility is over. If we are not able to receive it, you should contact the postal department. Postal department alone is responsible. That is why we register a letter and we send it by certificate of posting to evidence the fact that we have posted the letter. So, acceptance is said to be complete. Communication of acceptance is said to be complete as against the offeror the moment the acceptor has posted the letter. As against the acceptor, communication of acceptance is said to be complete when it reaches the knowledge of the offeror. Offeror must have knowledge about acceptance. Unless he has knowledge about acceptance, he may not be able to know whether the offer has been accepted or not. So, communication of acceptance is said to be complete as against the acceptor when offeror gets knowledge about acceptance. Therefore, here it is said, the acceptor is in an advantageous position. How? When once he posts the letter, one responsibility is over. But mere posting of the acceptance letter is not enough. It should be received by the offeror. Offeror must have knowledge about acceptance. So there is a time lag between the date on which the letter has been posted, the date on which the offeror gets knowledge about acceptance. Therefore, the acceptor is in an advantageous position. He can revoke the acceptance. So that is that. I am just mentioning it just like that. Now that is the next important rule. Next important segment is, that is the important rule is, then an acceptance must be before offer lapses. An offer lapses when it is not accepted in the prescribed manner. An offer lapses when it is not accepted within the prescribed time. An offer lapses by death of the parties or by the insanity of the parties. An offer lapses by revocation. An offer lapses by counter offer. So acceptance must be before offer lapses. Just now I enumerated the circumstances under which an offer lapses. An offer lapses when it is not accepted in the prescribed manner, within the prescribed time, by counter offer, by death or insanity of the parties, so on and so forth. So these are the sub-rules which I have now narrated. That is there. Then next important thing is, an acceptance must be by the offeree. Acceptance must be by the offeree. Then any acceptance that is sent by telephone or telex or through electronic medium, you see, it concludes the contract only at the place where the message of acceptance is received, not at the place where the message is communicated. So these are the rules which you have in mind while reading the rules regarding offer and acceptance.